Good morning, class. Today we are going to learn about cultural and educational rights. When we talk about these rights, we are talking about the rights of the minorities such as the Sikhs, Christians, Muslims, Buddhists, Jains, Parsis and so on living in our country. Now, these are in minorities because their number in the nation is not huge. Hindus are in majority because they are large in number. Now, here these minorities, they have the right to preserve their language, preach their language, script and culture, their traditions, their food habits and so on and so forth. Now, in the matter of admission to any educational institution maintained by the state, admission cannot be denied on grounds of religion, color, caste, creed or sex. Now over here they have just said that any educational institution maintained by the state. It also applies to any educational institution which is run by the minorities or any other institution as such. No educational institution, maybe it can be an inter-college or a vocational institution, cannot deny admission to a student on these particular grounds. Now, minorities and educational institution. Article 30 gives all minorities the right to establish and administer the educational institutions of their choice. You study in Sofia and you know very well that it is run by Christian missionaries. So, I don't need to explain this further. Now, the state is also prohibited from discriminating against educational institutions in the matter of grants. Grants are financial help which you get from the state. Now, when we are talking about the state over here, we are talking about not just the number of states which India is divided, but we are talking about the nation or the country as such. So, the state cannot say that no, it is a Christian institution, so they will not get any financial help. They have to give if needed. So, they have to give help to all kind of educational institutions. Now, right to constitutional remedies. This is considered to be the most important right which is mentioned in Article 32. Fundamental rights are justiciable. How? Please keep on underlining. That is, a suit can be filed in a high court or the Supreme Court if fundamental rights are violated. If somebody infringes on your fundamental rights and you are not able to exercise them. Article 32 gives the right to constitutional remedies. Underline, this right is given to citizens to move Supreme Court for the enforcement of other fundamental rights conferred on them. Conferred on them means given to them. By whom? By the Constitution. Dr. Ambedkar described this article as the heart and soul of the Constitution. See, if any of our fundamental rights, it can be the right to equality, the right to freedom, then the right to information, the protection in respect of conviction, preventive detention, then we are talking about right to freedom of religion, right against exploitation, right to equality, right before law. All these laws will have no meaning. All these rights will have no meaning unless we have the right to constitutional remedies, because it only gives us, see, if any of the rights which I talked about earlier, if they are violated or infringed upon by the state or by any other individual, then what can we do? We have the right to constitutional remedy. In essence, it is the basic nature. It is not a right but a remedy. What is remedy? A way of solving. Now, underline under this article, the Supreme Court and the High Courts within their respective jurisdiction. What is jurisdiction? An area within which a particular law is practiced, are empowered to issue writs. Now, let us see. Please underline what a writ is. A writ is a formal written order issued by the Supreme Court and the High Courts to provide legal remedies to individuals who do not obtain adequate protection under ordinary laws. The laws which are ordinary laws see if any of our rights are infringed, or we are in trouble, or we are being exploited by the state or some individual, we have the right to approach the lower court at the police and the lower court at first. But then still we do not get the matter remain unsolved, then what do? We have the right to constitutional remedies. Now, as per the Constitution, the enforcement of the fundamental rights underline issuance of writs, making of laws by the Parliament, and suspension of this right under very special circumstances have all been taken care of under different clauses of Article 32. Now, the rights before, the right to religion, the right to preventive detention, and all such other rights, right to life and liberty, all these rights, when we were learning about them, they had some kind of limitation. So this is what we are talking about, and suspension of this right. So where have they been taken care of? In different clauses of Article 32, subparts, that is. Now, important writs. Now, writs are just in simple language, understand it like this, that they are the orders. Habeas corpus, it means to have the body. By issuing such a writ, the High Court or the Supreme Court can get the body of any person released if it has been unlawfully detained by any person or a group of persons or by the state. This writ is thus a great safeguard for the personal freedom of a citizen. So, to get this issued, we have to go to the High Court or the Supreme Court. Now, this happens in case the district court detains somebody unlawfully, or the police or the district court detains somebody unlawfully, and the proof or the evidence is provided to the High Court or the Supreme Court for this, then the writ is issued and the personal freedom of the citizen is granted. Now, mandamus. In Latin, it means we order. It is a command or an order from a superior court to a lower or an administrative authority to perform a certain duty. In case, let us talk about an old person, elderly person who has retired from any place of it can be a government organization or a private organization, and he is simply not being given his pension on time. So what can he do? He can approach any court of law and then provide all the information over there along with the evidence and proof that he has not been paid. So in such cases, I believe also that a mandamus will be issued to that particular authority, organization, or people who are looking after it, and they will be paid their pension. Now, writ of prohibition. The writ of prohibition is an order issued by a superior court to a lower court to stop proceedings in a case which might be in excess of the jurisdiction of the lower court. Now, children, if you are ever interested in reading the news and all, then or listening to your parents talk, all the elders talk at home, then you must have observed that seen the books, read some books or seen some movies in which they are saying, no, you cannot file a case over here. You have to go to a different police station because this is not under our jurisdiction. That we can only do anything according to the law in this particular territory. So similarly, the writ of prohibition is that when the superior court, it can be a Supreme Court or a higher court, will tell a Supreme Court might tell High Court, or the High Court might tell a district court that you have to stop proceedings in this case because it does not fall into your jurisdiction. It is not the area in which you are supposed to work. Now, writ of certiorari. This writ is issued by a Supreme Court to a judicial authority desiring to be informed of what is going on. Now, what is going on in a particular case. Now, though it appears similar to the writ of prohibition, there is a difference. What is the difference over there? Now, writ of prohibition, children, what is happening is issued when proceedings are going on. Certiorari is issued after the court order has already been passed by the lower court. A decision has already been taken by the lower court. Now, quo warranto, it means by what order. It is issued when a person has usurped any office. Usurped any office to take powerfully without the right to do so. Okay, maybe somebody who is criminal, okay, they can take over some office, or somebody or an official who is not trustworthy may take up any office which is not due to him. So this writ thus prevents public officers from forcibly or wrongly holding a high public office. A corrupt official can be stopped from, in this case, a corrupt official also can be stopped from doing something wrong, or taking up a higher office by force or violently. Now, the writs make the right to constitutional remedies the most important and also make it an effective tool for their enforcement. Though presently only the Supreme Court and the High Courts have the power to issue these writs, the Parliament can confer similar powers on other courts. So right now only the Supreme Court and the High Courts of the different states have the power to issue these writs. The district courts do not have the power to issue these writs. But in future, maybe with further amendments and all, there can be a change in this also. Now children, please go, all these writs are very important. Please go through them again. You should know them by heart. Now, fundamental rights at a glance. This is very important, given in a nutshell. So please learn it on your own. Read it and learn it on your own. Right, important over there. And in case if you have not understood something, please note it down and we will discuss it again when the school reopens. Thank you.